welcome to everybody who's joined us so far. Um, we're glad you could be here, and we'll briefly introduce ourselves. Please go ahead, Bruce.
Yes, nice to meet all of you, if only virtually. My name is Bruce Ewing. I am a trial partner in Dorsey and Whitney's New York office, specializing in trademark and copyright litigation for more than 30 years.
And I'm Sarah Robertson. I've worked alongside Bruce for over 2 decades. I'm a trademark partner in the New York office of Dorsey, and Bruce and I are both deeply involved with brand licensing, both from a drafting and litigation perspective. So we're here to share a few insights, some tips, tricks, and some industry information that we hope will be helpful. I guess as a housekeeping matter, we will speak for 50 minutes roughly, but we will stay on the line afterwards for 15 minutes or so to take questions. I think we're unfortunately too big of a group to take questions as we go, but please put them in the chat so that we can try and address them at the end. So we're just going to start with a poll to see, get some sense of the expertise of our audience, and if our support has been able to launch the poll. Okay, there, it should come up right now. So how experienced are you with brand licensing? You know, what's a brand license? Which is fine. I encounter them from time to time, and I am very experienced. Please plug in your answers so we get a sense of the expertise of our audience today. So here's our data. So we've got the majority of our audience is sort of in the middle. You encounter them from time to time. A third of our audience is quite experienced, and then we've got some newcomers to the area. So we'll certainly have some basics and also some more nuanced, sophisticated context, which I think will allow everybody to benefit from today. So let's just start with some really basics. You know, what is a brand license? And it is where a mark owner who would act as licensor grants contractual permission to another to use that trademark on agreed on terms. And absent that license grant, the user of the mark, the non-owner, would be a rights infringer. Historically, and this is the reason why we're mentioning this, is that trademark license in the past was considered legally impossible, since the primary function of mark is to indicate a single source. But it became legally permissible where a licensor or the mark owner remains in control of the mark and the quality of the goods and services that are sold by the third party, and so quality control is really at the heart of trademark licensing, and we're going to go over that. But it really is a key concept to allowing the use by another without relinquishing rights. And as I said, we'll get into that a bit more later. So why license a brand? And this comes up in a multitude of contexts. The first is just leveraging brand recognition, and this is maybe the more traditional brand license, where a brand has a good consumer penetration, goodwill, and has the ability to be extended to other categories based on that goodwill, since it will enhance sales in expanded categories. It's also a business strategy, a way to enter new markets cost effectively. This could be new price categories. It could be new countries. There may be a number of market or business conditions that are in place where somebody other than you is better suited to sell or market in a particular market or trade channel or country. New revenue streams, if you're looking to bring in enhanced revenue, certainly it hedges fluctuations where one category is down, another may be up, and spreading a brand use over a number of categories can help hedge against fluctuations. It's also a way in terms of an IP asset to actually build up a brand strength and scope of protection. If you have concerns about use of your mark in categories that you may not otherwise be in a strong place to enforce, entering into a brand license to enhance the scope of rights and also to increase strength, licensing is a inroad to do that. Sometimes where we have a contentious issue over a third party's use of a mark, a license to allow that third party to continue to use as a exit to a dispute. It's not always a perfect one since the parties entered into the arrangement in a contentious situation, but it is a settlement option that's looked at under certain circumstances. Co-branding or other marketing strategic arrangements it could be a co or mutual license. Increase the selling price of the product. There's objective data about particularly entertainment properties where with the brand or entertainment product or content put on a product, it's a way to increase the sale price. This also comes in the entertainment context where if you want to use it as a promotional vehicle, certainly there are t-shirts, promotional items, other merchandise that can surround a movie launch, an event, other ways, music bands, other ways to effectively promote the underlying event or entertainment. Avoiding regulatory restrictions on advertising. This can come up in regulated fields such as alcohol, cannabis, tobacco, but certainly putting a mark on a hat or a t-shirt is one way to avoid some of those restrictions. Boost innovation. This is an industry trend that we're seeing people moving into new and innovative categories, including innovative digital uses such as digital clothing, metaverse applications. That's another reason to license. So Bruce, I'll turn it over to you.
Thank you, Sarah. Sarah has just outlined the many great things that can come from a trademark license, but there are also at times downsides, and it's not uncommon for disputes to at some point emerge into litigation. So as happy as everybody was at the time that the license was signed and looking forward to the new business and the new opportunity and all those great synergies that Sarah described, there are more frequently than one would like litigations that arise out of license agreements, particularly in the trademark space, but also with other types of intellectual property. So Sarah's sort of going to be the fun side of this presentation, and I'm kind of the downside. So I'm going to be offering a series of the most common types of drafting issues that give rise to litigation. I should note, by the way, that there are certainly others, and that this is not meant to be an exclusive list. Also, that there is no one-size-fits-all approach to preventing a lawsuit. But what you can do is try to mitigate the risk that a lawsuit will result by following these general principles, recognizing that they may vary from situation to situation. The one point that I want to emphasize at the outset that is the most important is that many intellectual property attorneys think of licensing as an IP-related subject, which it is, and absolutely the things that you know and learned about intellectual property are very important to a successful license agreement. But even more important are the things that, for those of us who are lawyers, that we learned during our first year of law school, which are basic principles of contract law. And you may recall your contracts professors all telling you about ambiguity and how courts assess ambiguity in the context of contracts. Ambiguity is the enemy of the license agreement drafter, because when agreements are unclear or ambiguous, a couple of things are going to result, and none of which are particularly good. And the inquiry that any court undertakes begins with, and in some cases ends with, the language of the contract, the license agreement. Courts are going to look first and foremost at the terms of the agreement that appear in front of them on the printed page or in the digital image these days. So it will be, or a dispute will focus on not what the parties thought they had agreed to, or wish they had agreed to, or considered agreeing to, or even talked about agreeing to, but what is on the printed page. You only get to so-called parole evidence, which would be emails back and forth preceding the execution of the agreement, or notes of telephone conversations, or drafts of the agreement, if the text is ambiguous. And you don't want to get there in the first place. You want to avoid that completely. So ideally, you will be as precise as you possibly can in a license agreement, recognizing that there's no surefire way to avoid ambiguity in every situation. If we could go to the next slide, Sarah. So what happens is that if a court looks at the agreement and concludes that the language is ambiguous, it's highly likely that there will have to be a trial. It's not impossible, but you are very unlikely to get summary judgment when a court finds that contract language can be read in two different ways by reasonable people. And of course, when you get to a trial, the outcome is much more unpredictable, because now, instead of the parties talking among themselves about what a contract provision means, they'll be relying on a judge or a jury to determine what they meant at the time they signed the contract. So avoiding ambiguous contract language whenever possible is paramount. If you could go to the next slide, Sarah. Thank you. I've seen a lot of unfortunate license disputes during my time practicing law. These are the sort of 6 general categories as to why these things happen. They don't necessarily matter to the outcome of a case, but they can shed light on how the ambiguity emerged into the agreement, and perhaps how to solve the problem once the dispute arises. It is commonplace for deals to be rushed, especially at this time of year, where everyone is running around trying to get transactions closed by December 31st. I have a case study at the end of my portion of this presentation. For years, I had one that was about Del Monte. There are actually 2 different Del Monte companies, one covering fresh vegetables and the other that sells canned vegetables and produce. And they were once one company, but they were split apart. And then there was a license agreement that was entered into by one to the other. It was entered into literally over a period of just a few days while the transaction was closing. I actually learned that from one of the attendees at this presentation that I've done before. So a rush deal is sort of a recipe for ambiguity. Likewise, there are many occasions where lawyers don't understand the business goals of the deal, and therefore you get language that doesn't quite fit the transaction. So it's important, especially if you're negotiating a deal with a third party in-house and also outside, but particularly in-house, that you understand what is it that the business people want to accomplish, and then you can figure out how to express that goal or capture that goal in contract language that you draft. Standard forms for licenses. Everybody has standard forms. I have standard forms. I'm sure lots of you out there have standard forms. There's nothing wrong with standard forms, to use them as a starting point for a licensing transaction. But you have to be aware of that there's not necessarily a correlation between your standard form and the particular transaction at issue. So you really have to be careful about it and make sure that the form you start with fits the transaction that you're now drafting an agreement for. There are many occasions where a license is part of a broader transaction, like a sale of assets or an acquisition of stock. Perhaps the brand's rights are divided in different ways. It's important that somebody be sort of the ombudsperson and make sure that the documents are not inconsistent and that they all kind of fit together properly. It's hard to do that, especially in a big deal where there's a lot of people working on one portion of the transaction, and the trademark lawyers might just be working on a separate part. But that's sort of communication among the members of the deal team in terms of making sure that the license fits in with the overall transaction is very important. because otherwise you run the risk of having a license agreement that says one thing and a broader set of deal documents that may suggest something else. Sometimes, and this happens more often than probably anyone would want, the parties are under a lot of pressure to get a deal done. They can't agree on particular language, and so they opt for an imperfect solution by basically just consciously deciding to leave language ambiguous, in the hope that nothing will come of that. In many instances, there aren't any disputes, and this is not an irrational strategy to undertake, especially when you're under a lot of pressure to get a deal done. But it definitely has risks that go along with it, and you're better off, solving the problem now while everybody's incentivized to do so than waiting until later after a dispute has arisen. The last category, which I've called whoops, is just a mistake. There are agreements where the word not, for example, should have appeared in a sentence but doesn't. That's obviously a real glaring example of something that's wrong. I'm sure that all of us have seen contract provisions or have looked at contracts where we're reading along and suddenly you encounter a sentence or a word or a paragraph that has nothing to do with the particular transaction. And that's probably because it was a holdover from a standard form or another form. And so you see the name of a party that isn't part of this agreement. These things do happen, and frankly, they generally don't give rise to litigations, but they can at times. So you've always got to proof your documents carefully before you sign. Next slide, Sarah. The types of ambiguities that can plague license agreements is as varied as the number of ambiguities out there or the number of stars in the sky at night. It's a lot. Generally speaking, here are some of the main ones. There's sometimes ambiguity about what is it exactly that's being licensed. So, for example, if you're licensing a trademark, does the logo go along with it or not? What if the mark is used in a particular color? Is that part of the license or not? What about composite marks, where you take a licensed mark and it's accompanied by other words, which may or may not be generic or descriptive? If you're better off in a trademark license being very specific and clear about what it is that's being licensed, or at least capturing that, any variation of this mark that the parties agree on is part of the license. It's not some new thing. In the copyright context, what about derivative works? It is not uncommon at all for a licensed work to evolve or change over time. And if that happens, is the derivative work that's created part of the license or not? In the patent context, it is very common for there to be subsequent patents that spring out of the original licensed technology, improvements, and then in some cases unpatented technology that is developed out of the originally licensed patented technology. So your license agreement should really be clear in terms of trying to capture all of these things to avoid a dispute later about ownership or otherwise. Goods and services in the trademark context are very important. So you want to try to specify as best you can what is it exactly that is that's being licensed in terms of a product category. So, for example, a simple license for apparel is super broad and would cover really many different types of things, some of which the licensor may not think of as apparel. So you're better off being specific. If you want to be that broad, frankly, including things in Class 25, which is the international trademark class that covers clothing, is probably a better way to go than simply saying apparel. The more specific you are in terms of what's being licensed, the less likelihood of an ambiguity and therefore a dispute down the road. There are times where the licensee takes the license but doesn't really exploit it. They have an affiliate, they have a subsidiary, they have a partner in some cases who winds up being the one selling the marks. And that's risky for the licensee. The licensor may say, wait a minute, sometimes years after the fact, what are you doing? How can you be selling these products? We didn't sign up a deal with them. We signed up a deal with you. And in fact, our license says no sub-licensing. So what's going on? To the licensee, the other entity that's, from a technical perspective, exploiting the mark, the licensee may consider that entity to be one and the same with it. So but it can be tricky. And so if you're the licensee and you're planning to exploit the mark through a related company, or you change your mind partway through the transaction and decide that that's what you want to do, it's best to make that clear upfront in writing. The approval process, which Sarah will be speaking about shortly, is very important in any trademark license. It's best to define the steps in the approval process specifically, as well as the standard that will be applied by the licensor to granting approvals. And that is particularly true with respect to product quality. Can we go ahead?
Yep.
As I mentioned, trade channels, in addition to products, is another aspect of licensing that can create ambiguities, particularly since there's sometimes disagreements about what is meant by the use of particular terms. So, for example, club stores, I think everybody knows what those are, and that would be Costco and Sam's, and the sort of store where you sign up to be part of the club and then you can shop there. Mid-tier retailers is a term that has changed significantly over time. Specialty stores is often used as a catch-all, and there are differences of opinion about what is truly considered a specialty store or not. A big issue in many licenses is the ownership of ancillary intellectual property. So if I'm a toy licensee and I take a well-known mark and I create packaging for a toy product bearing that mark, who owns the package design? Is it me or is it the licensor? Most licensors want to own that packaging, and their agreement will probably say so. Licensees, however, sometimes think otherwise, and often the license just doesn't say. If the license doesn't say, given that packaging is a type of copyrightable work, the licensee probably owns it, absent some sort of work for hire or assignment language in the license. So that's an important factor for really mostly for the licensor to think through. The territory should always be defined clearly in the agreement. If it's the world, that's fine. I think there are potential risks to granting a worldwide license when you're not sure you have worldwide rights, but that is something that people do, and it can be a problem. Net sales, which I want to touch on briefly, is by far the most important economic term of any license. And it is one that unfortunately is often not the subject of enough attention from the lawyers drafting the agreement. You really have to define net sales very specifically and clearly, because that's usually what royalties are paid on. What deductions are there going to be from net sales, if any? Is it just going to be returns? Is it going to be allowances, whatever that means? Trade discounts are sometimes deducted. There are any number of deductions that licensees want to have to drive that net sales number down so they pay as little as possible. In contrast, most licensors want there to be as few as possible deductions from net sales, so that they can maximize their return. Again, net sales of all the provisions in any license agreement is not the one to overlook or just gloss over. It really needs to be specifically and clearly defined, recognizing the adversarial interest, if you will, that a licensor and licensee have on that issue. Renewal rights are very important to licensees. Most large licensors really won't negotiate licenses anymore. If you are trying to deal with one of the larger entertainment companies, one of the larger tech companies, anyone that owns a lot of brands, the basic terms of their licenses are probably not likely to be the subject of much negotiation. But the one thing that a licensee can often get, and should absolutely make sure they get, is a guaranteed renewal right on specific terms if they hit certain conditions, or ideally without any conditions at all from the licensee's perspective. That's not all that common. Usually the licensor wants the licensee to not be in breach and to have attained whatever minimum sales the agreement might require. Those are important terms in a license agreement. but if you're the licensee and you don't bargain for and get a renewal right on terms favorable to you, you are at significant risk that the business you built is going to be taken away from you at the end of the license term and handed off to somebody else who did not invest anything in it. So that is a significant concern from a licensee's perspective. Termination rights are important to define in an agreement, and you want to be clear about what grounds there are for termination and what impact a breach along the lines that are specified has. Is there going to be a cure, for example, or is there not? Some licenses define breaches that are material in the agreement itself. I should emphasize, though, for those of you who are in New York, even if the agreement doesn't allow or say anything about termination for material breach, you are always allowed, unless it's restricted in some way, to terminate a contract when there has been a material breach. I have seen licenses that go on and on and on about all the grounds that the licensor has to terminate and what will happen in the event of a particular type of breach, and that say nothing about a termination right on the part of the licensee. Well, the licensee still has the right to terminate, even if the agreement doesn't say so, at least under New York law, because if there is a material breach by the licensor, then the licensee can walk. And so licensors, I think, don't pay enough attention to this issue when they're drafting these agreements. Could we go to the next slide? Quality control in a trademark license is very, very important. It is essential that the trademark licensor maintain and control the quality of the goods that its licensee is selling. There are risks of abandonment or through so-called naked licensing if the quality control provisions are not adequate. It doesn't take a lot, quite frankly, to have an adequate quality control provision, but you got to have one, and it can't just be in the agreement. You actually have to take affirmative steps to assure the quality of the goods that are being sold under your mark. There is often a question about what is the standard of review for a licensor when it is looking at product submissions. Is it an objective standard or a subjective standard? And there are sometimes disputes between licensors and licensees on this issue. And it really depends on two things. First of all, the language of the contract, and also the subject matter of the contract.
Bruce, on the quality control issue, what, I've seen license agreements with very detailed approval processes that can range from all stages of production. But what do you, in terms of the case law, and it is a case-by-case basis, what do you think the minimum is? I guess at least some type of clause in a license, or what do you think the bare minimum is to avoid a naked licensing allegation?
The bare minimum would be an annual review of the product line to make sure that they are that the products are fit for sale, not damaging, consistent with brand guidelines, and that the licensor has gone through them, approved them, and they can be sold. You don't need, if you're the licensor, you should want a very detailed and specific approval process so that your brand is protected. But if you're not interested in that for whatever reason, then what you would want to do is have an annual get-together with your licensee, show the entire product line, go through it all, and then approve it. And be sure to document it, by the way, in case there's a complaint later that the quality control process was insufficient.
So I think
the objective standard is one in which the goods must adhere to a specified standard of quality as determined by the licensor in its reasonable discretion. So when you see license agreements that give the licensor the right to approve goods, but through the exercise of what's called reasonable discretion, that is an objective standard. The licensor's ability to reject goods is more limited when you have an objective standard. A subjective standard, which is where the goods must be satisfactory to the licensor in its sole discretion, is much more favorable to the licensor, although it's not without its limits either. You can't, at least in New York, you cannot arbitrarily reject product submissions because you want to get rid of the licensee, or because you don't like the color yellow, or for some other made-up reason. You have to act. There's always an obligation of good faith in any contract, and particularly in a licensing relationship with respect to the exercise of approvals. The type of product, as I mentioned, also matters. Generally speaking, if you're dealing with something like industrial equipment, you're more likely to have an objective standard in those types of agreements, because there's just not a lot of room for subjectivity when it comes to approvals in those types of spaces. Whereas if we're talking about fashion or art or entertainment or something like that, you're much more likely to have a subjective standard, because beauty really is in the eye of the licensor in those types of situations. And that's the standard that you will most often see in those types of contracts. I should say that if the agreement doesn't say, if it simply says that the licensor can grant or withhold approval, and without saying, it's something like based on its reasonable discretion, if it's silent, the objective standard is what the court will impose, on the theory that if the licensor wanted the subjective standard, it should have bargained for that.
So that's helpful, Bruce. So we're just going to cover a few other considerations that can come into play and can be addressed in a license to ensure that the value and goodwill attached to a brand that you are effectively handing over to somebody else to use is preserved throughout the license. Because as we went through before, the notion of a license is that your rights ideally should be enhanced through the process, not diminished at the end. And these are some other considerations that come into play that can really help to preserve rights. One is having an acknowledgement, an express clause in the agreement that the licensee acknowledges a licensor's exclusive rights and ownership of the trademarks, which can potentially assist in the event of a challenge or potentially an allegation of abandonment of rights, naked licensing later, an agreement not to challenge or contest the validity of the trademarks, an agreement not to register a trademark or any other source designation in a manner that's confusingly similar or suggestive. So you don't want your licensee to indirectly adopt a mark that comes close, either post-license or if there's some variation that's developed during the course of the license that's unauthorized. So this would come up post-termination, where they need to stop using your mark and anything else that's confusingly similar as well. Brand manuals is another way to control quality presentation, ensuring that there's a uniform brand vision. This can be colors, this can be font, but the more precise parameters that you can communicate to a licensee, particularly where there's more than one licensee involved, can really help control how a mark is used and the nature of the products in question. This comes up more often than not, where not only is a license mark put on a product or put into a use for a service, but it's adopted in other ways. Sometimes the licensee will rename itself with the brand name, or create an entity that has the brand name in order to commercialize the license, or adopts a DBA. They'll register a domain name with the trademark, social media account. All these things need to be considered and expressly provided for, and certainly should only be undertaken with a licensor's consent. Disposal of unsold goods. Often in a license, there's a sell-off period post-termination. For example, 6 months is not uncommon. And in an effort to maximize profits and knowing that the relationship is over, a licensee can be in a hurry to dispose of the goods, and they may consider discount outlet channels to move goods quickly during that transition period, and certainly controlling where the goods can be sold can preserve brand value. I've certainly seen goods in bins at discount stores that can tarnish a brand image. Data breaches is just something I'll mention because certainly it's not something that's considered as part of a brand license, but certainly any poor, unlawful behavior, negative PR that occurs to a licensee during the course of the license can indirectly or directly serve to tarnish a brand and can be addressed as part of a license, potentially as a ground for termination. So these are some other peripheral things to consider. Bruce, I'll turn this back to you.
Yeah, one issue that comes up frequently in licensing disputes is best efforts provisions. To be candid, I don't like these and generally don't want them in agreements, especially when I'm the licensee, but I'm a bit dubious about them as a licensor as well. Are best efforts provisions enforceable? I have had more than one client say, of course they're not. What does that mean? Well, that's wrong. Best efforts provisions are enforceable, provided there is some objective way to measure, how the efforts are best. Generally speaking, when best efforts clause is at issue, a court wants the party subject to the clause to pursue its object in good faith to the extent of the promisor's own capabilities. So now, look, as I said, I'm not a big fan of these, and rather than having a best efforts provision that people can argue about, because in some cases there isn't an objective way to measure best efforts, writing into the contract objective milestones and targets instead of a general best efforts requirement is usually preferable. We can go to the next page.
Excuse the lag.
Yeah, now, in assessing a best efforts provision, it is not required that the licensee or whoever is subject to the best efforts provision bankrupt itself or undertake Herculean efforts that are unrealistic in the context of the marketplace to satisfy the object of the clause. Nor does a small company, for example, have to do what a larger company might have to do. But what you cannot do if you were the subject of a best efforts clause is say, well, we tried, we read it, and we attended a trade show and we made some calls, and that was sufficient. That's not enough. It has to be able, the party subject to the clause must be able to say that they did their subjective best. And if they passed up obvious opportunities to live up to the clause, that's going to really hurt you. So again, best efforts provisions, contrary to popular myth, actually are and will be enforced, at least in certain circumstances. And if you're not sure that your client is going to be able to live up to a best efforts clause, try to change it. The objective standard that courts will look to can come from a variety of sources. It could come from the text of the agreement. For example, if there's a best efforts clause and also minimum guarantees or minimum ad spend requirements, well, I don't see how you could have undertaken your best efforts if you didn't achieve those. So that's one way that a court might assess the enforceability of a best efforts provision. Industry custom and practice is often a source for the objective standard that a court will look to, and expert testimony, expensive expert testimony often comes into play here. And then, of course, there's also expert testimony that's separate from or divorced from industry custom and practice, and simply the experience of an expert in a particular field. I would encourage everyone to avoid the 3 words that I put in quotations at the bottom of this slide. For a long time, I saw this, and then I didn't see it for a long time, and now it's back. In the last year, I've seen this at least 3 times in agreements. I do not know what reasonable best efforts means. The first 2 words there are not consistent with each other, and they are inherently ambiguous. Years ago, when I was out of town eating dinner at a restaurant with some friends, the item on the menu was diet chocolate decadence as a dessert. I feel the same way about that dessert as I do about these three words. They're simply not reconcilable. And so put in commercially reasonable efforts. That's perfectly fine. Or best efforts, but merging the two of them, in my view, is not a good idea at all. Notice and cure provisions. Nobody pays any attention to these things when they're drafting the agreement, but you should. Courts generally want them to be strictly complied with. Notice is a notice. It's a formal written document that basically says we're putting you on notice. You don't have to use the word notice, but you've got to, it's got to look like a notice. Whining emails about how you didn't do this and you didn't do that are not notice. And there's actually case law to that effect. And for goodness sake, send the notice in the way that the agreement requires. If it says send it by certified mail, send it by certified mail, although I really discourage the use of certified mail. It's just a huge imposition on everyone's time. Send it out in the way the agreement requires. If you know that the recipient is no longer there, or if you think certified mail is going to take too long, still comply, but just send out the notice in other ways too. That way you can be sure it gets there, and send it to somebody you know is there, who hasn't left, as well as the designated notice recipient in the contract. But you should always comply with the notice provisions of an agreement. It is important in my mind that the agreement require whoever is sending the notice to specify the nature of the breach in reasonable detail. It's important for a number of reasons, for both parties, quite frankly. If you're the licensor, you want to be able to lay out exactly what the licensee did, so you're not accused later of acting in bad faith. And if you're the licensee, you want to understand what it is you did, so perhaps you can cure it if a cure period is afforded to you under the contract. Generally speaking, if the notice articulates 2 or 3 breaches, and then later one party wants to claim that there was another breach, there's difficulty in doing that. You might be stopped from not including that later breach in the notice, unless it was a breach that you didn't know about at the time. And when you're sending your notice of breach, be sure to identify the specific contractual provisions that you claim were breached. Sarah alluded to this earlier during her last segment. In trademark licenses, when they're terminated, they're terminated. Your right as licensee to keep using the license mark has ended. It doesn't matter that you still have a lot of inventory that had been approved previously. It doesn't matter that there are orders pending for certain goods. You can't sell them unless the agreement permits it. And in many instances, the agreement doesn't, or at least it imposes conditions on a sell-off. So you cannot simply walk away from a license agreement and just assume that you're going to be able to keep selling goods. And this is a very, very important issue if you're the licensee and you are planning to terminate. You have to understand that if you're going to walk away from a license agreement, you had better get rid of your inventory before you actually do it, because you're probably not going to be able to sell it off once you end the agreement. And you do not want the economic downside of getting stuck with a lot of goods that you can't sell. Finally, arbitration clauses are commonplace in license agreements, and they can be a fantastic idea when they are properly drafted. However, an arbitration clause that simply says the dispute will be resolved through arbitration is a recipe for endless fighting. There are several different major arbitration providers out there. The AAA and JAMS are the 2 biggest. Specify the service that you're going to be using. Also, specify the number of arbitrators that your proceeding will have. The AAA has a default rule if there's no number specified. I believe it's if the dispute is over $1 million, it's required that 3 arbitrators be appointed. If it's below $1 million, only 1 will be appointed. So you really want to take control of that issue yourself when drafting and put into the agreement a number of arbitrators. What rules are going to govern? There are many different types of arbitration rules. It's very easy to specify which rules will govern, and whether it's the version that's in effect at the time the agreement is signed or at the time the dispute arises. It is not uncommon to write into an arbitration clause provisions regulating discovery. If you don't, then you're going to have to figure that out once the proceeding gets started. But you can write in and say, There will only be document requests. There will be no depositions or no interrogatories. You can write all of that into the contract, and the arbitrator will follow it for the most likely. Sometimes people write into arbitration clauses that the parties, will go to the AAA and the dispute will be resolved within 60 days after it's commenced. I can assure you that is not going to happen. And I'll tell you why. It can take months to get the arbitrators appointed, especially when you're talking about 3 as opposed to 1. So if you're going to include a time limit, which is probably not going to stick anyway, at least start the clock running when you've picked the arbitrator, not when the dispute is filed. It's very unlikely you're going to get anything resolved that fast. 6 months, okay, that's a different story. In arbitration, there is the concept of the reasoned award, which is the equivalent of a judicial opinion explaining the arbitrator's thinking about why they decided the case the way that they did. Sometimes parties want these. In fact, usually parties want these. Sometimes they don't. If you want a reasoned award, you can write that into your clause, and then you don't have to worry about that later. And if you want the arbitrator to have the ability to grant injunctive relief, you should say so. Because if it's not clear, it's possible the arbitrator may conclude that they don't have the authority to issue an injunction, and you may be left going to court to get injunctive relief in aid of arbitration after the proceeding is over.
Just before we move into your case example, Bruce, I'm just being mindful of time. Just we want to raise one point with the increasing importance of the online world, both for sales and marketing, of the importance of expressly addressing it in a license agreement. What online uses can a licensee make both to sell and to market, and what online channels can be exploited. So there are things like, online retail sales, as I mentioned before, social media account names. There obviously can be competing online presences between a licensor, a licensee, or multiple licensees. And so it's very important to carefully think this through and control what online presence a licensee has. URLs, can a licensee set up their own website? Mobile apps, which exist both for consumer service and also for sales, delivery of certain services. The metaverse is another, digital universe that can be attractive to certain licensees, but we must be clear about who can exploit that world and who cannot. Digital versions of products, this is a important hot area right now, particularly in the fashion area, where there's a desire on certain platforms such as video games for players or users of those platforms to customize their avatar or other digital presence in those universes, and they're looking to buy t-shirts, other areas. It can be certainly another area to monetize a product, and the digital versions should be addressed. Consider whether supplemental filing coverage for non-product classes is needed. For areas like the metaverse, digital equivalents of goods, classes like class 9, 35, and 41 have been settled as appropriate classes for digital equivalents, and that supplemental coverage should be considered if these online channels will be granted. And then briefly, just before we got through that, just briefly, AI. This is a generative AI in particular is being increasingly used in connection with the marketing and sale of products. We can't dispute that marketing text, visuals, images, certain AI tools are being relied on increasingly to create new products, create new recipes, develop marketing text, marketing images. As of late, there's been AI chat tools, consumer service tools that are interacting with consumers to answer customer service questions. All these things are happening with increasing frequency. And obviously, generative AI raises ownership issues, and there's been a struggle with the law, and particularly copyright law, to provide protection to those types of new content creations. Right now, the Copyright Office has given clearer guidance, and the case law has also settled that there'll be no copyright protection at all unless there's a human element involved. And there'll be there's a Copyright Office study underway right now based on a recent order that Biden put out. So there should be more specific guidance. But right now, there's no protection at all. And so this creates issues, for example, where a licensor will acquire the rights that a licensee's developed, or where a licensee is counting on a licensor to provide it with certain marketing collateral. There needs to be clear disclosure on both sides about AI-generated products so that the ownership risk can be managed, and this should be provided for in a license. Just as an aside, the Federal Trademark Commission has stepped in quite visibly as of late to indicate that it's going to really focus on consumer deception aspects of use of AI, consumers not knowing that something is AI generated, who they're interacting with. And so in a license agreement, we do recommend that there be some reps and warranties on the, depending on what side you're acting for, but surrounding responsible use of AI and AI identification, so that these aspects can be managed, knowing that they can be helpful tools. So Bruce, I'll turn it over to you for your case study. We're at 5 to 2, and so I think maybe we'll do this for 10 minutes and then take questions if that sounds feasible.
Yes, and we will go through this quickly. So this is a case study about ambiguities in license agreements from an actual case that was decided earlier this year after several years of very expensive and involved litigation. A couple disclaimers. I was not involved in this case, so I have no inside information at all about it. And secondly, I've simplified the facts somewhat because there was a lot going on in this case. So this is the core issue in the case. Does the term, the definition of beer that was contained in a license agreement cover hard seltzer or not? And, keep this definition handy in your mind. I'm just going to read it because it's the whole case, basically. Beer means beer, ale, porter, stout, malt beverages, and any other versions or combinations of the foregoing, including non-alcoholic versions of any of the foregoing. Okay, that is the issue in the case. Just 2 lines and a word that spurred a massive amount of litigation. We could go to the next slide. Okay, here's the background on the case. The plaintiff is Modelo, the famous beer company, and the defendant is something called Constellation Brands. And together in 2006, they set up a joint venture called Crown Imports to distribute Modelo branded beer in the United States. Modelo owns the Corona and Modelo trademarks, widely used with beer. And the beer definition that I just gave you comes from this 2006 joint venture agreement that was set up between them. Okay, 6 years, nothing happens. 2012, Anheuser-Busch, which owned a portion of Modelo, announced that it would buy the balance of the company, all of it. In 2013, the Justice Department gets involved and it says, basically, wait a minute. We are very concerned that Anheuser-Busch buying all of Modelo is too much market power, and they initiated a lawsuit to enjoin the merger of the 2 companies. Next slide.
Yep, it would be just one line.
So the lawsuit was resolved not long after it was filed by Modelo agreeing to divest itself of certain assets to reduce the market power that the combined Anheuser-Busch Modelo business would have. Among other things, Modelo sold off to Constellation a whole bunch of assets related to Modelo's U.S. business, including a brewery, and most importantly, for present purposes, Modelo's stake in the Crown joint venture for roughly $4.75 billion. Modelo was required as part of that settlement to grant Constellation a perpetual royalty-free license to use the Modelo trademarks, including Corona and Modelo, with, quote, beer. Again, the same definition from the 2006 joint venture agreement. All right, now we go ahead 3 years. Hard seltzers are introduced in the United States for the first time. It's hard to imagine a time where we did not have these beverages, given how popular they are. But at the time, they were not on anyone's radar screen. Constellation started its entry into this market segment by selling Svedka Spiked Premium Seltzer, Svedka being a vodka brand that Constellation controlled. The product was a flop, and it was withdrawn after weak sales. But the next year, Constellation came back and introduced Corona Refresca, which was a flavored malt beverage. And what it did was, since it was a Corona branded product, it did go to Modelo and say, we're going to be selling this product under the license that we have, and we want you to be aware of it. Modelo said, fine, didn't object at all. Then the next year, Constellation launched a series of hard or spiked seltzer products produced from a sugar base, but with no hops or malt as ingredients. And that is one of the key facets of this dispute. So first you had this Corona Hard Seltzer Variety Pack 1, and then Variety Pack 2 for March of 21, and then Hard Seltzer Limonada, June of 21. And then Corona Hard Seltzerita in July of 21. So all these products come into the market, and they are a big, big success. Hundreds of millions of dollars very quickly being generated, and Modelo is not happy. It's not happy because it actually wants to introduce its own line of hard seltzers, and it's deeply annoyed that Constellation is using its marks to sell these products. The agreement had a mandatory mediation provision in it that required the parties to try to resolve their dispute before any lawsuit was filed. So those discussions occurred. They did not succeed, and Modelo filed a lawsuit in the Southern District of New York in February of 2021, even before some of these products came out, asserting claims for both breach of contract and trademark infringement. And the case was assigned to Judge Kaplan, who many of you may know from the E. Jean Carroll Trump defamation case, as well as the recent Sam Bankman-Fried criminal case. And essentially, Modelo wanted Constellation to stop selling these products, at least with the Corona and Modelo names on them. Okay, Modelo's position was the Corona Hard Seltzer products are not beer and therefore outside the scope of the license. Their argument was beer is beer. It means what it says. There's a common understanding of what beer is, and beer is an alcoholic beverage that includes malt or hops as ingredients. And that's what various dictionary definitions say. And that's what New York law, according to Modelo, would say, because there was a New York choice of law clause in the agreement. They pointed to other evidence as well. Constellation on earnings calls over time repeatedly separated its hard seltzer business from its beer business. And it also did that when public statements were made about its business. At the time the Crown joint venture was established, Constellation stated that non-compete provisions in the joint venture agreement concerning the distribution of beer would apply to malt-based products, such that a product like the Corona Hard Seltzers, which did not have malt or hops in them, were excluded and therefore unauthorized. Under the agreement, and I've actually never seen anything like this before, as part of this mandatory license, Constellation, acting as agent for Modelo, could register Modelo and Corona marks within the scope of the license agreement, and there was really nothing that Modelo could do about it. It was basically an unlimited grant of rights cabined by the parameters of the agreement. So Constellation filed originally an application with the Trademark Office for Corona Hard Seltzer to cover, quote, alcoholic beverages except beer, hard seltzer, i.e. not beer, flavored malt-based alcoholic beverages, excluding beers. And so Modelo said, aha, this means that you, Constellation, understand that there's a difference between beer and hard seltzer. Constellation said that wasn't true. And by the way, they abandoned that application later, and they filed a separate application that just covered hard seltzer. And of course, there was a lot of expert testimony about what was and was not a beer. So that's the Modelo side of the scale in this dispute. Among other things, Modelo also pointed out that that Constellation, it was perfectly fine, telling us all about Corona Refresca and asking for our approval, but you didn't tell us about all these other products, so you were hiding things. That's another argument that was made. And then one of the Constellation was really focused on the regulatory framework for the distribution, sale, and taxation of beer. And Modelo was really focused on dictionary definitions, arguing that there was no evidence that the parties in drafting the agreement adopted any technical understanding of beer that was different from the common understanding of that term. Okay. Modelo also argued that Corona hard seltzer products are not versions of beer, which was another argument that the Constellation had made. They said, a Honda motorcycle is not a version of a Honda Civic. It's a completely different product. And then there were arguments about what version means based on competing dictionary definitions as well. So again, that's the Modelo side of the fence. On the Constellation side of the fence, they hammered this point repeatedly. There is nothing in that definition that says that beer has to contain malt or hops. And in fact, the definition uses the words beer and malt beverages, treating them as separate things. So according to Constellation, those terms would be redundant if a beer had to be a malt beverage. Why would you separate the two of them? They also, as I mentioned, really hammered the state and regulatory frameworks governing the sale, distribution, and taxation of beer. The relevant regulations do allow for the brewing of beer using substitutes for malt and hops. And that's why the Corona hard seltzer product said on every can that the product was a beer. It said it in very small print, but all of the products were labeled as beers from a regulatory perspective. We could keep going. The Internal Revenue Code is what really was the focus of these arguments from Constellation. The Internal Revenue Code definition for beer allows for the brewing of the beer with any substitute for malt, sugar being the substitute that Constellation was using. And so they argued if U.S. law considers our product to be a beer, and we're dealing with really sophisticated parties, how could our products not be beers? Constellation really poo-pooed the dictionary definitions of beer, saying that they were irrelevant and contradictory. Some of them, in fact, were like the IRS code and did allow for substitutes other than malt or hops. The parties repeatedly in their advertisements over time had treated hard seltzers as beers. Constellation also noted, the whole point of this mandatory license and the divestiture of the Crown joint venture was to prevent Anheuser-Busch from having too much market power. How is that goal furthered, asked Constellation, by having a situation where the brands, Corona and Modelo, could be used by this supposedly really too big company, Modelo, when the idea was to have the market made more competitive. And so they argued that the underlying purpose of the license wouldn't be furthered by treating hard seltzers as beer. Or not as beer, excuse me. Also, there were other provisions of the license agreement about brand extension beers. And so they argued, Constellation did, that there were inconsistencies in the agreement that would be created by the definition that Modelo was trying to use. Of course, Constellation had its own stable of experts who would testify, and they argued as a backup that Corona hard seltzer products are versions of a beer and therefore permitted under the license in the same way that a Tesla electric automobile is a version of a standard automobile. So those were the arguments that each side made. Judge Kaplan denied summary judgment to both sides. the end of 2022, he found that there was ambiguity in the agreement, that it was not clear which parties' competing definitions of beer would ultimately apply. So a jury trial was held earlier this year. I'll tell you the result in a second, but first we want to know what you think. Based on what I've told you, are the Corona hard seltzer products beer as defined in the license or not? And you've got three choices: yes, no, or you're not sure.
So we've got the overwhelming majority saying no at 61%, 30% say yes, and 10% of you are not sure. So, so Bruce, most of our audience says it's a no. What was the outcome of the case?
Well, the jury disagreed with most of our audience. The jury actually concluded that the Corona hard seltzer products were beer, were permissible under the license agreement, and they continue to be sold today. I should note that an appeal is pending right now with the Second Circuit, so somebody else may have the last word on this. But that just goes to show you, and I'm not faulting anyone involved in this at all, because the development of the hard seltzer market was not anticipated by anybody involved in the drafting of this agreement. So I think there's an argument to be made that this agreement was not ambiguous at the time it was drafted, but it became ambiguous over time. And, you know, there's just not a lot that that lawyers in an imperfect world can do to prevent that. But it, as you can see, it led to a huge dispute with hundreds of millions of dollars at stake, and ultimately a jury verdict that was needed to resolve it. So that's it, I believe, for this presentation. If anyone has any questions, here is a question.
Yes. So here, I'll read out the question if you want, Bruce. Do you have any further best practices in protecting licensed brands in the EU, specifically France, where agency laws vary from those of the US? You know, I have some familiarity with the agency structure, and I know it's very agent protective, and that there's a lot of statutory restrictions. For example, it can make it hard to terminate in those instances. And I think this is a highly specialized area, but certainly the agent protections would need to would need to be considered, particularly for termination. You know, here I would want to get very specific advice in terms, particularly on the termination front, where there's a license that extends to the EU, to allow for these, including termination periods, which can be very long in France. But do you have any other anything else to contribute on that point, Bruce?
I do not. I am strictly a U.S. litigator, so that's outside of my wheelhouse.
Yes. So we have a second question. What do you think about agreements with, for example, software vendors that request the ability to use your mark on their websites, indicating you are a customer? Agree to that or not? Actually, this comes up certainly on some of the marketing or collaboration agreements that I handle, where typically termination clauses provide that, or this can come up with vendors as well, where termination agreements provide that you basically got to erase without a trace any use of the mark, but that there can be a desire to note either the existence of the relationship or to keep, not be required to delete historical posts, for example. And I think typically we think these can be okay, especially where there was a successful relationship. But our way of dealing with this is usually where there's and I guess as a fair use perspective, these can be in some cases hard to stop, since it may not be a brand, for example, a brand used on product, but generally we'll put these into a contract where this can be done with a licensor's permission. So you can agree to them in the right circumstance, but putting in a consent clause can help control that. And I think, just see if we've got another one in here. Hang on. And I think that is all the questions that we have, unless I'm seeing this. I think that's it for questions, but certainly we have a few more minutes to answer some others if anything comes to mind. We'll see no more questions, and just being mindful of time that we're at 2:13. I think we'll end things there, but please feel free to reach out to Bruce or myself with any follow-up. And we're grateful for the robust participation today. We hope you found it helpful.
Very nice to see all of you.
Yeah.